Well, welcome everybody to this afternoon's community service presentation of our board education and training. I usually tell you that I'm Ed Zelmansky, but since we're live, I guess you can see that I'm not. So I will tell you that I am Stacia Miller. I'm one of the associate attorneys with Zelmansky, Danner, and Fiorito out of the Mount Clemens office. You will hear Miss Melissa Francis, one of the associate attorneys out of our Plymouth office with Zelmansky, Danner, and Fiorito. I will be moderating on Facebook. Melissa will be moderating here on Zoom. And our wonderful presenters today are Mr. Ed Zelmansky from Zelmansky, Danner, and Fiorito, Mr. Greg Fiorito from Zelmansky, Danner, and yep, you guessed it, Fiorito, and Mr. Ed Castellani from Fraser, Trebilcock, Davis, and Dunlap. We are going to be presenting on various issues that you're going to be facing during your restart after this pandemic shutdown. You're welcome to ask questions. If you've joined us on Facebook, put those on chat and I will pop back over here and present them to Ed, Greg, and Ed. If you are on Zoom, type them into chat and Miss Francis will present those questions to our presenters. Without further ado, I believe Miss Francis has a few housekeeping things that she would like to announce before we begin the actual presentation. Welcome.
Hi, welcome to our presentation this afternoon. As Stacia said, I am Melissa Francis and I will be moderating the Zoom portion of the presentation today. If you go into your toolbar, you should see the chat box. You can open that up, keep it up throughout the presentation. If you have a question, you have the option, you can message it to me privately, or you can just put it in the entire chat. I will get to that question when there is an appropriate break in the presentation, as Stacia will do on Facebook. So without further ado, I'm going to introduce Mr. Edward Zelmansky, and he will start the presentation.
Yes, good afternoon, everybody. I hope that everybody's well and will remain so. I'm a partner in the firm of Zelmansky, Danner, and Fiorito, and been practicing law for over 40 years now, and have still seen new things. Seen new things with the coronavirus. That has been a challenge and remains a challenge, but we are here today to help you deal with the challenges that are posed by the virus, and in particular, we're looking forward to things starting up again. So welcome this afternoon. I'll be talking about issues with restarting the performance of contracts for your association, and look forward to getting started on that. I think Greg Fiorito is going to speak for a moment now.
Nathan sends that out. Everyone let me know about the replay.
All right, I'm back. Can everybody hear me now? Ed, can you hear me now?
I can. Thank you, Greg.
Thank you. I'm Greg Fiorito. I am a partner with Zelmansky, Danner, and Fiorito. I am a U of M graduate, so go blue. Hopefully at least half of you are blue out there. I've been doing condo and HOA work for the last 17 years, almost exclusively, and I've been an attorney for 20 years. I specialize in not only general counseling for HOAs and condos, but also handling document amendments, rental amendment, and fair housing issues and insurance issues. I'll turn it over to Ed Castellani.
Thanks, Greg. Yes, I'm Ed Castellani, and I am an attorney and a CPA with Fraser, Trebilcock in Lansing. And I'm a business attorney, and I have developed a specialization in nonprofit law. So I've been asked to speak today, and I am going to speak on issues affecting nonprofit corporations that have resulted from the pandemic. So I'm happy to be here, and thank you for having me.
Thanks, Ed. Thanks for being here. I wanted to just say a brief word about the strategic alliance we have between our firms with Zomancy, Danner, Fiorito, and Frazier Trabilcock. It's a unique relationship. It's kind of unusual. We're still two separate law firms, but we joined together to create certain benefits for our clients and for our attorneys. One of those benefits is that we are able to share office space, so we're able to reach clients across the state now in Detroit, Grand Rapids, in Lansing, where Frazier has their firms, as well as our offices in Plymouth and Mount Clemens. So both firms are able to reach clients across the state. Frazier Trabilcock is more of a general service law firm, whereas our firm specializes in condo and HOA law. There's a cross benefit of being able to share the knowledge of our attorneys, share our attorneys, make referrals if needed to get those areas of law maybe the one firm doesn't practice in. So a lot of benefits for ourselves and for our clients, more importantly, and also do educational events like this where we can share expertise together to educate our clients. So that's really what the strategic alliance is between our firms. And with that, I'm going to turn it back over to Ed Zomanski to begin the portion of the presentation dealing with agreements and contracts.
Thank you, Greg. Well, your organization, you have agreements that have been in place, contracts, and things were interrupted by the COVID-19 pandemic. And, well, so many questions, so much confusion, a lot of fear, a lot of dashed expectations arise here. And I think, certainly during times like this, we look to the law. What does the law tell us? How does it guide us? What are our obligations in light of all these changes? How does the law address issues regarding the performance, continued performance of our existing contracts? And so what do we get from the law? Force majeure. We get legalese and in French, by God. And so what does this mean? This is a clause that appears frequently in contracts. Back to the previous slide, please. Okay, there's a definition of force majeure. Force majeure refers to a superior or irresistible power, an event that is a result of elements of nature as opposed to caused by human behavior. And so that sounds like the coronavirus. Yes, force majeure is very much on the tip of many attorneys' tongues these days as we're looking at the legal implications of what has happened to us and what will happen, particularly as we start dusting things off and moving forward again. So force majeure is important because it presents a form of relief for parties that might feel as though the COVID-19 virus has really derailed their operations. This force majeure clause frequently will appear in contracts. It excuses parties from obligations under the contract due to events that were not within the control of the parties. This is sometimes referred to as an act of God. And you'll see that term act of God frequently in contracts where they'll say, well, if there is an act of God, something that arose that was not within the control of the parties, then that act of God can excuse performance of the contract. So what happens? If you also have some other legal theories that will address this situation, frustration of purpose is another legal theory, similar to force majeure clauses in contracts that says, well, basically parties had entered into a contract and there was a reason for the parties, entering into that contract, and now that reason has been frustrated, so that will excuse the performance. There's also something about another theory called impossibility of performance. And impossibility of performance operates in much the same way, that it's just no longer possible for a party to perform their obligations under a contract, so the law will excuse them from further duties on that. So where do we go with this? Contracts do not contain the word pandemic. The exact wording used in a contract is going to be a key factor when interpreting the meaning of the contract. Each contract will be interpreted by reference to the contract wording and the facts and circumstances involved with the parties in the performance of that agreement. So that's important to keep in mind, that when you're talking about your community or your association's contracts, the answers to the questions regarding performance or resumption of performance of obligations under a contract are going to have to be directed to the language of the contract itself. You may expect that, let's say in Florida, attorneys drawing up contracts for resorts might have something in mind when they were drafting those contracts that would tend to limit the ability of a party to get out of a contract because of the occurrence of an event that might be described as force majeure. Maybe, obviously no one knew about COVID-19, so I doubt that you'll see COVID-19 in the written language of any contract. So we're going to have to take a look, what's the answer to your question? Let me see that contract. You're going to have to read the contract and understand the circumstances. Let's look at some sample language here. No compensation of a cancellation fee related to a scheduled game shall be paid to either party in the event it becomes impossible to play the scheduled game because of inclement weather, an act of God, strike, lockout, or other labor dispute, any decision, law, rule, or regulation of the NCAA, or any other federal, state, or municipal agency or official. An increase in the number of annual conference games required by either party's conference, or the occurrence of any other material event that is beyond the reasonable control of a party. Here is a full and rather classic force majeure clause that actually this comes from a contract for the University of Michigan football team. It's part of a contract that in particular was reported to be in the language for engaging Arkansas State University to play a football game in September in Ann Arbor. So if you look at it and say, well, what do we have going on with COVID interfering in the performance of this contract? Certainly, we had a rule of law or regulation of a federal, state, or municipal agency. In this case, the state shutdown order would be a classic example. If the governor says that you cannot gather to play football games, then that's a pretty clear force majeure that would excuse the performance of this contract. We know that this game was scheduled for September 19th. Some more background is that Arkansas State derived 23% of their annual athletic department budget from the anticipated revenues they were going to get from playing the University of Michigan in this football game this year. So the opening round was fired by the athletic director of Arkansas State, who informed the University of Michigan that Arkansas State intends to be in Ann Arbor to play that game. You can imagine how the dialogue would go after that. the contract would have a cancellation fee that a defaulting party would have to pay if they wanted to cancel the contract, and that may well have been specified in terms of an actual dollar amount, maybe a couple $100,000 that would have been negotiated by the parties to the agreement. And here, the University of Michigan might say, well, this is beyond our control. We cannot play the game, so we don't owe you a cancellation fee. Well, we don't know at this point whether a game will be played. There's still discussion about continuing sports activities. Things have been relaxed. There are a lot of people that are hopeful that these games will be played, perhaps with a limited audience. But there's a good example of knowing the facts and circumstances that apply to resumption of performance of a contract, and how that force majeure clause in that contract might come into play in determining the continuing obligations of the party to that contract. So what we need to do in your particular cases, as I suggested, the individual facts and circumstances of your association and its contractual obligations have to be analyzed in detail. And one of the things you need to look at is, did COVID-19 actually cause an interruption in performance of the contract obligations? One of the things that we look for and we see already is, yeah, I can't honor the terms of the contract, COVID-19. And so COVID-19 becomes what is referred to as a get out of jail free card that excuses any performance you would rather not render under an existing contract. But the analysis would be, has this really, COVID-19 really caused an interruption in the performance of the contract obligations? And depending what those obligations are, you know, it's like, well, did COVID-19 really stop you from being able to do that, or is that a convenient excuse? So that's going to be a factual issue when discussing these things. I have to say, government bans on activities are generally viewed as force majeure. As we noted in the U of M football contract, there it talks about, you know, a rule enacted by the government would be a reason to excuse performance. So if the governor of Michigan says that the University of Michigan cannot hold that football game, then that would end all discussions pretty much on that. So when you're looking at continued performance, you know, it's going to, government bans will be an important factor. Let's say you had a contract for landscaping, lawn treatment, that sort of thing, that called for a number of payments throughout the season and a number of services that were to be performed. And of course, we know that the governor's order precluded performance of those duties for that time. So we can't say, well, landscaping company, you know, you're in breach of the contract because you did not perform. Landscaping company says force majeure. The governor says I could not perform. Now that the governor has lifted that, those restrictions, then the continued performance of that contractual obligations proceeds without reference to the continuation of the government intervention as a force majeure. Force majeure where it's applied in contracts usually relates to the delivery of goods and services rather than the payment of money. So if I have the duty to pay my mortgage, then I say, oh, COVID-19, I can't pay. Well, no, that's, COVID-19 is not a force majeure that froze my checkbook. I see that we have a question that came in. Can the landscaping company say, we had a contract and you have to pay us? Something like snow removal is paid for the season, not for the specific delivery of the service at a specific time. there, with the matter of snow removal, think that you're maybe talking like the frustration of purpose, something like that, to say that you could not remove our snow because of limitations imposed by COVID. So there was no possibility for you to perform that duty. So we have no duty to reimburse you for performance that could not be rendered. I think what you would do with that, a lot of these discussions are going to be, of course, you're looking at the future, and you're going to look at the parties to that contract, the person you have that agreement with, and say, what are we going to do? All right, we'll do this next year. And so a lot of times agreements are being reached where deposits that maybe you've placed will be transferred to a rescheduled event next year. And those sorts of negotiations are occurring frequently. I know one of the things that Ed Castellani mentioned was, some associations that perhaps had conferences scheduled that they had to cancel because of the coronavirus. That would be a classic force majeure where you say, well, wait a minute, we really couldn't fly there and couldn't be lodged there. I happen to have heard some discussion suggesting that some of these resorts were not so understanding. And so the negotiations between those parties proceeded in earnest. And,
Hey, Ed,
yes.
I just wanted to interject maybe a clarification. I know on the board of directors that I serve for my association, as the question said, you pay in a lump sum. Often for these contracts, you pay ahead of time. What if you paid ahead of time on one of these contracts, like a snow removal contract, and then COVID hits, and then they couldn't perform? Like, how do you think that, in that scenario, are you entitled to a refund then of what you paid, even though you paid it maybe before COVID began? Does it depend on what the contract says? Is that maybe you could address that scenario?
Greg, that's certainly going to depend on what the contract says. And snow removal contracts, they tend to get kind of detailed because I think these snow removal companies see the vagaries that are introduced into performance just by the weather, which is so unpredictable. Say, well, it never snowed, so I don't have to pay you. Well, the possibility of it never snowing was contemplated in all likelihood. And so, well, you still owe that money. Well, it never snowed, but you were never in a position to perform the contract. You were never really on call because you could not have sent a crew out here to have removed the snow if it had snowed. And I think, that's an example of a frustration of purpose, a force majeure that would excuse the payment under that contract. Again, I think, as we've suggested, you need to look at that contract and what do the payment terms say? That it's, this is due now, come hell and high water, and that's a term that is used in contract interpretation. Come hell or high water, that money is owed. Such a contract might entitle that snow removal company to retain monies paid.
So read your contract, I guess, is what you're saying. It's going to be very, especially for those types of contracts. Also, landscaping is very often the same. You pay a lump sum fee. The snow removal, I think, would be a little bit maybe not as relevant to us because, at the time when COVID hit, but landscaping, certainly contractors could not do landscaping work, right? So I think that, certainly the types of things we're discussing certainly would come into play, you know, with those types of contracts. Would you not agree?
Yes, totally. You know, and there can be varying degrees here too. It'd be, well, what if you have a landscaping contract for the season that calls for weekly mowing and it never rains? So, you know, it'd be like, well, you know, there's no reason for you to be out there mowing dust. You know, you could see where, you know, on the other hand, a rainy summer, they're going to be out there wearing their equipment out. And I guess to a certain extent that was contemplated by the parties, that there would be those variations. So that's not the sort of thing that's going to excuse performance so much. On the other hand, if there were an absolute drought or, you know, just some dust bowl sort of occurrence that was seen as an act of God or a natural occurrence that wasn't anticipated by the parties, then you may be in a position where you say, well, no, because of the drought, you were never going to mow the lawn. And so that contract, you know, we're not going to pay you for that. So, you know, again, you can see how important the individual facts and circumstances will be in measuring how these changed circumstances will impact your existing contracts and how you will move forward.
And Ed, going back to, this is Melissa, going back to your football scenario, the question is, what if one party is under a ban of gatherings such as football games, but the other is not, and the game is to be played at the one that is not under the ban? Can force majeure still apply?
That question, I would say no. In our case, say, okay, the game was to be played at Arkansas State and they had no ban. And so the Michigan team would say, oh, we're under a ban here, we cannot play in Ann Arbor. Well, that's not what we're talking about. You know, the details of the contract, we're talking about playing in Arkansas. And the game can be played in Arkansas. So you would not have the benefit of the force majeure clause excusing performance.
Ed, I had a point I wanted to mention. Just, you mentioned frustration of purpose. And, you know, we know as lawyers that's a legal doctrine. What's the relevance of that? What does it mean for the sports fans at home? And how does that relate to force majeure?
Well, force majeure refers to clauses in a contract, and we looked at the University of Michigan football contract, and that language would be, you know, recognized as force majeure language, and that's just language in the contract, and it's enforceable. Frustration of purpose is a principle in contract law that will look at the basic assumptions underlying the parties entering into that agreement. And as a matter of law, frustration of the contractual purpose will excuse performance if the contract, you know, has not otherwise addressed it.
Okay, so two different things. In force majeure, you're saying is that's going to be a contractual clause that the clients would look for regarding performance or non-performance and COVID, whereas frustration of purpose just applies as a legal defense to non-performance, would you say?
Yes.
Okay, I thought so.
Okay. Well, what the heck? Neither party caused this problem. So what do? Well, I think you've gathered from my comments, both parties need to sit down, apply reason, common sense, and fairness to find a solution to move forward. What are we looking to accomplish here? Yeah, we know things didn't quite work out this summer. We are interested in maintaining a contractual relationship. We know both sides have had a hard time. Like I said, neither party caused this. So, you know, sit down, have respect for each other and each other's needs and how this impacted both parties, and try and find a solution. Number two, consult with your legal counsel so that you can have a review of contractual documents and the principles that would apply. Litigation, sure, there's going to be litigation on these issues. Currently, the courts have been closed. They're just starting to open back up. Go back to the first 2 points above. Both parties need to sit down and apply reason with the benefit of consultation with your legal counsel.
Yeah, I just agree. And one thing I'd like to add to that, Ed, is, everything's negotiation. Even if, I guess what the contract might do is set the parameters for starting point of negotiation, right?
Yes.
One person might start with the advantage because, we have a force majeure clause. So we're sitting pretty, we don't have to perform because of COVID, we're all good. But if you want to have a long-term relationship with that vendor, you're still going to have to work together, right? And if you want that client, you still got to do business together. So even, the clause may be irrelevant ultimately, other than to set the initial bargaining positions of the parties. You still got to, like you said, you got to be reasonable and come to the table still and negotiate something, I think, that works for both sides if you want to have that working relationship.
Absolutely.
All right. Well, I guess I'm next. Is that correct? Okay.
Yes.
Good to go, Greg.
All right. COVID-19 and insurance claims. I'm going to talk about insurance issues and liability issues for organizations and condos and HOAs in particular. I get a lot of questions about this, especially the pool example. So I'm going to start and continue with this example throughout my materials. Will a community association's coverage protect the board and the association from COVID-19 related claims? Will the insurance coverage protect you? And let's use this example, the pool. Everybody wants to know if they can reopen their pool, or if they can, should they reopen their pool? But a lot of these principles and ideas we're going to talk about apply just the same to other types of amenities, like if you're reopening your clubhouse, for example. That's probably a big example. If you're reopening your jungle gym that you have for your kids at a condo. So, these materials will apply broadly, but we're gonna focus on the pool because it's a real hot topic as we approach the summer. So what I'm going to talk about is, in the context of reopening the pool, 4 different types of insurance that are at issue. Number one, you have directors and officers, which is known as DNO insurance. This protects the board of directors and officers for decisions that they make while they're operating the association. Number two, property coverage. Obviously, if property of the association, the condominium, is damaged, you want to have coverage to replace that. Number three, general liability. Okay, you get sued, somebody slips and falls on your property, you need that general liability to protect your association from claims. And number four, workers' compensation. If you have employees, workers' compensation will protect them if they get injured on the job. So those are the 4 types of insurance we're going to talk about. And again, feel free to share your questions or just comments even in the chat. I'd like this to be an interactive presentation. Don't be shy if you want to chime in. All right, number one, DNO coverage. So here's the $64,000 question, or perhaps, the $640,000 question. We're talking about a claim. Okay, you reopen your pool. Will you have DNO coverage? Okay, if somebody sues you, let's say they go to your pool, even though you're doing all the right stuff, they contract COVID at your pool, and they sue the board of directors and the association. Are you going to be protected? Are you going to have liability? Are you going to have coverage for damages? And are they going to pay for your defense? Those are the 2 main components of your coverage that are important to associations. Well, here's the bad news, and there's a lot of bad news on this topic, unfortunately, if you're looking for coverage, because it's pretty much not going to be there. And this is a huge point. DNO, there's usually an exclusion, and this is almost universal in such policies, called a bodily injury exclusion. So if anybody suffers bodily injury indirectly or directly as a result of that decision in question that the board made, that is going to be excluded from coverage. Okay, excluded from coverage means no coverage. And if there's no coverage for damages, then there's no defense. Why is that important? Well, even if, let's say, you did the right things, and let's say they can't prove that you caught COVID at your pool, okay? If there is no coverage because of an exclusion, then there is no defense also because of that exclusion, okay? Why is that important? Because the coverage of defense, that in and of itself could bankrupt many associations. Most associations that I know of don't have $100,000 set in their bank account to defend litigation, even frivolous litigation, or even litigation that they're likely to win in the end. Okay, even if so you have to pay for the cost of the defense, regardless of whether ultimately you'll probably win that case. So this we're going to call the BI exclusion. It's going to exclude coverage. So the wrongful act in this case for the DNO is the board's decision whether or not to reopen that pool. That's the decision in question. So that triggers the wrongful act element of your coverage, but you're going to have that BI exclusion. And so for that reason, you're not going to have DNO coverage to protect your board members, okay? So they possibly could have individual liability or have to defend themselves. Now, one important thing to mention about claims and different types of claims, this BI exclusion would not apply to what they call a non-monetary claim. Non-monetary claim would be somebody sues the association to force them to open the pool or to force you to close it. Okay, that's not asking for money. That's just saying we don't agree with the decision the board made and we want you to take certain actions to correct that decision. So as long as you have good insurance, and again, I've seen policies where this is also excluded, but if you have a good policy, usually this won't be excluded. And you'll have coverage for a non-monetary claim, a breach of contract claim, breach of the covenants.
Greg,
as long as you have that coverage and there's no exclusions, you're going to, that type of decision, that type of claim would not be excluded. So that's the difference there. So, if you're thinking about what decision should I make as a board member, are you going to make the decision, the result of which is an insurable situation, or are you going to make the decision where the result of which is not going to be insurable? Either way, you could be sued. But you want to put yourself in the position, at least if you're sued, there's coverage. So that's a big reason why a lot of the insurance people that I've been talking to, that Ed Zolbansky's been talking to, and attorneys like us talk to, they say this is a big concern for insurance companies and for their association clients, because there is just not going to be coverage for your associations. And I'm not an insurance lawyer by trade. I'm a community association lawyer, but obviously I've talked to a lot of these people. I want to give a special shout out to Scott Breslin from McCready Insurance, who helped me in putting this presentation together. But all these insurance professionals are telling me the same thing, which is this is a very risky situation. And it's not a situation that you want to be there having no insurance coverage. All right.
Okay, Greg, this is Melissa. I have a few questions. So the first question is, how does someone prove that they contacted COVID in a particular location?
Well, that's going to could be very difficult. That goes to causation. If you're going to sue the association on what they call a negligence basis, do you have to prove causation? Yes, you do. You have to prove that what they did caused my injury. So you reopening the pool, whatever you did, I got sick from that. So yeah, you do have to prove that. How are you going to do that? I mean, I think it's going to be difficult. It's going to be a factual matter based on the circumstances. If it's a pool, they're going to look at and see, was somebody that was known to have COVID there? I mean, it's not going to be easy. It's not going to be, and this is a big question we get. It's like, how do you, we hear what you're saying, but how do you prove it? How could you possibly prove that I caught COVID from your pool? Well, I'm not saying it's not going to be difficult, but anybody knows that, at least lawyers know, people that deal with them, it's very easy to file a lawsuit, okay? And even if it's a frivolous lawsuit or a lawsuit that the plaintiff is likely to lose, it doesn't stop the party from filing it. And if they file it, you have to defend it. So even if causation would be very difficult for somebody to substantiate as a matter of fact, you could still be on the hook for tens of thousands of dollars or more in defending that claim if there's a catastrophic situation. So the causation issue does not solve the problem. You know, the problems they're going to have improving causation does not, you know, absolve or go, it doesn't make these insurance concerns, lack of insurance concerns any less.
Okay,
Right.
so then,
Yeah, Ed, you
I'd
want to
like to just add to that, you know, you talked about the catastrophic nature of these losses, and I think that's important to understand the, you know, seriousness of this issue. When I talked in my part about litigation in these contracts, you know, if you're going to litigate a dispute with a painting contractor, the amount at issue is going to be such that, you know, right away you're going to outspend the amount actually in dispute in legal fees as opposed to your claim for damages. So it's like, find a way out of that. Here, with the COVID situation, you're talking about a serious bodily injury or death. And so those kind of claims, you know, the stakes are high. And as I said, I have not seen Sam or Mike Morse or Feiger advertising that they're handling COVID claims at this point, but you know you're going to see that. And that's, you know, part of the analysis is that a COVID related claim is likely to be for kind of higher stakes. And so the risk in play there, the potential risk in play needs to be evaluated with that in mind.
I agree, Ed. It's just the magnitude of the claim has to be considered also, you know, along with the probability of the claim. Even if the probability of the claim is low, you think the probability of this actually happening or somebody actually prevailing, the damages could be, you know, talk about possibly $1 million. So, you know, when you put the two together, you multiply two numbers together, the probability versus the amount of damages is still a pretty large number because it's a large liability. We're not talking about a $20,000 claim. So I want to just, there's a couple questions, and
yeah, I was gonna say I have
on the next slide, but I'm going to address some of the chat questions real quick. If, you know, somebody gets hurt at the pool, generally you have liability coverage, okay? So that's a different type of coverage. So yes, if somebody breaks their leg at the pool, right, you have premises liability. That's why you have liability coverage already. You already have insurance for that. That's a different type of coverage. We're not talking about liability right now. We're talking about DNO. Okay, DNO is a specific, we cover decisions made by the board while they're running the association. DNO coverage has the bodily injury exclusion. So that answers Dan's question, I would hope. What else? What else? Or Jasper's question. Are you still there, Melissa?
Yep, I have
Okay.
I have some questions.
Okay.
Stacia messaged to me. Number one, can board members be sued individually?
Yes.
Number two, can they be sued for not opening the pool?
Yes.
And number three, because Washtenaw County is allowing pools to open with their COVID emergency preparedness plan filled out, how can the board not open the pool and not be sued?
Well, those are great questions, aren't they, Ed Zolmansky?
Yes, they are.
And I think Melissa Francis has done some personal research on the whole pool issue. We have a copy. Do we have a copy of those we could hand out, those Washtenaw regulations?
I do, and I will email them if you want to put in the chat. I'll email them with the copy of the presentation.
Okay, so everybody heard that. Melissa Francis has the Washtenaw pool reopening guidelines. She will email them to anybody who wants them. Just pop it in the chat and ask her, and she will do that. What did you say something, Melissa?
Nope, I didn't.
Okay. So yeah, so Washtenaw County has those regulations. They're the first county of the major counties to do that. You know, the point is the reopening does not give you a get out of jail free card. Just because the government's opening the pools doesn't mean there's no risk. Okay. So it's not, you know, you're not home free just because we're reopening. And the insurance people I talk to, they're very firm about that. So I don't think that this is all over because, you know, Gretchen Whitmer says you can reopen the pools or the county says you can reopen the pools. Two separate questions. Okay. Somebody could still say, look, you were totally negligent in maintaining that pool, or you were grossly negligent in following the COVID guidelines. We're going to sue you. I don't care what the government says. So there's no get out of jail free card. There's no immunity there. What was the other?
The next question is, if the pool is open and someone files a COVID claim, would that mean that the board would be sued individually since DNO would not be covered?
Yeah, you could be sued individually as a board member. And we'll talk a little bit about protections for board members with Ed Castellani. You know, you can put protections in your documents to protect your board members as a nonprofit corporation. There's assumption of liability and exclusion of liability provisions, which we highly recommend that nonprofits have in their governing docs and their articles of incorporation. So you need to have those in. It's really important right now to have those in. I was going to touch on that a little bit later too, but that's why it's so important to have that, because if there is no insurance coverage, you could have individual liability.
And then someone makes the comment that their HOA makes residents pay all legal costs. So what is the risk?
I mean, I'd say, I don't understand. I mean, you're saying everybody shares the legal bill, so it's not going to be onerous for us to pay legal fees as a community, if that's the point. I mean, communities I've seen get into major litigation, you know, of developer issues. If they have an additional assessment of $3,000, it causes a major uproar. So, you know, if you have that, you know, which could very well happen, you need to pay for the litigation, your budget doesn't cover it. So you got to additionally assess your co-owners or homeowners. You're not talking about, you know, $50. You're talking about a lot of money. So I don't think that, I mean, that's the reason why you want to be careful about this, because you're going to be left holding the bag as a community. You will be left holding the bag as individuals, because the individuals fund the association. The money's got to come from somewhere. There's no free lunch. So that's why it's so important to make the right decision here. Now, I want to get through the rest of my slides and give Ed some time. So let's move on to the next slide. I want to get through the rest of these, Melissa. All right. So next type of coverage, property insurance coverage. How might losses related to COVID be covered? What types of coverage? Well, property insurance. What about property insurance? Okay. You have property insurance on your common elements, your common areas. I mentioned this case, Sloan v. Phoenix. It's a Michigan case. It's one of the more seminal insurance cases on property coverage and you know, interruptions by civil authority, like we've had with the shutdown orders. The interesting thing about that case is the court said, you know, normally you have to have damage to property to get coverage for the damages. Okay, you have to have actual property damage. The court in this case said, because of the riots back in '68, the government shut you down and you lost income. So we're going to say that's civil authority coverage. You are covered under your property policy, even though you didn't have property damage per se. Okay, so that's a case where they came out to try to expand the interpretation of property insurance coverage. So, you know, going to our context, you might say, well, you know, if our business was shut down by Gretchen Whitmer's orders, then we should have coverage under our property coverage insurance policy. So whatever organization you are, if you're a business corporation, you know, you have to look at your policy. Again, see if you have exclusions, okay? Because this is what's so key. Not only look at what's covered, but what's excluded. And this applies to condos, HOAs, and business, other organizations. You know, you could have an exclusion for this type of thing. If, you know, you could have exclusion for being prevented to open your business because of COVID-19, because of civil authority. So your policy may exclude this very thing, is my point. So again, read your policy, especially your exclusions. That's all important. Next slide, Melissa. All right, so that's property coverage, part one. Part two here, property coverage. As I mentioned, usually you got to have some actual property damage. Okay, so going back to the reopening the pool scenario, are we talking about damage to property? No, we're not talking about damage to the pool. It was mentioned to me that possibly there might be some property insurance coverage for cleanup costs related to COVID if they were required by a public authority. This was mentioned to me by some of the insurance professionals I've been talking to, but it was kind of an aside. There's mention of a $100,000 limit in their policies, but maybe for property limited coverage for that type of cost. But going back to what we're talking about, again, somebody's getting injured, somebody's getting COVID at the pool or at the common facility. You know, is there property insurance coverage for that? Not likely. Again, there are going to be exclusions. Going back to the exclusions, look for the ordinance or law exclusion in your policy. This would apply to, you know, when somebody, the government shuts down, regulates the use of your property. So excluding any losses related to that, or anything related to pandemic or biohazard. I'm quoting from an actual policy here that I've read recently, as far as the language you would see in the policy. Biological or pathogenic agent, engineered or naturally occurring, that it induces or is capable of inducing disease, illness or disease. So that's an exclusion straight from a policy where, again, no property insurance coverage. So long story short, there's no DNO, pretty much no property insurance coverage for this type of a COVID-related claim. Next slide, please. All right, so now general liability. Let's talk about general liability coverage. This is another type of coverage that organizations and associations have. And guess what? Yeah, you guessed it, no help. The problem with this type of coverage is there's a lot of exclusions. I guess that's the problem with all these coverages. But there's a specific one and related to liability coverage that is called the expected injury exclusion. So this exclusion says for liability coverage, if you make a decision and it is expected that somebody could be injured from that decision, no coverage. Okay, so in this case, the expected injury exclusion could exclude your coverage under your liability policy because one would say, look, you reopened your pool in the middle of a pandemic. The pandemic wasn't over. It was expected that some people could have COVID. They could bring it to the pool and other people could get it. You know, you might even have put warning signs up that said, hey, if you use our pool, be advised you could get COVID. Well, guess what? That's what they call the expected injury. You have no coverage. So again, not likely to have any coverage to protect you when, you know, co-owner gets COVID or gets, and they die or they get seriously ill and they sue the association for reopening that pool and for their illness. And again, you have the same exclusions here that you would have for your property coverage. The biological hazard and the communicable disease exclusions. Same exact language. The policy I looked at had the same exact language for both types of insurance coverage.
Oh, so
the exclusions eat up all your coverage, probably no coverage. Yes.
So Greg, would posting use at your own risk signs provide protection?
It is a good thing. If you're gonna reopen, you know, it is a good thing to post warning signs. You know, basically you're telling people that they assume the risk of their, what they're doing. There is some benefit to, if you're defending against a negligence claim, and my research shows that if you had a sign, at least, you know, people were put on notice that there was a hazardous condition and they could have, you know, decided not to use the pool. So there's some benefit to having a sign. And there's also some benefit to having waivers. But that's not a jail-free card either. And we'll talk a little bit about waivers in a minute. But so yeah, should you have a sign if you reopen? Yeah.
And can the exclusion for COVID cases, can that be overcome if the board hires pool attendants to enforce the county requirements so that then a COVID case could be covered?
You should absolutely have third parties handle your monitoring and your cleaning and all that. That was emphasized to me strongly by the insurance professionals I've been talking to. You don't want the individual board members volunteering. You don't want Tony Baloney from the board going out and being the pool policeman. You don't want that. That puts you directly in the liability crosshairs. You know, something is screwed up, they're going to blame you directly. So,
and then what if,
yeah,
what if as an association you have a vote and the members vote to open the pool? Can the director still be held liable?
That's a good question. I think they could because it's really a board decision. The power to open that pool in most associations is a board decision. It's not a membership decision. So any membership vote is kind of window dressing. It's like a straw poll. So that's not gonna insulate the board legally from a claim. You know, I don't think it has much of any legal effect. All right, let's go on to the next type of coverage. I can finish my slides here. I don't want to take up all time. Workers' comp, this one's kind of a minor issue. You know, many associations don't even have employees, but if you do, you know, that applies to any injury or disease that arises out of your employment, in the course of your employment. So somebody who in the normal course of their job would encounter sick people, you know, they're probably going to have workers' comp. Okay, with an on-site pool manager, they get sick while they're doing the pool management stuff. Would they have workers' comp? Maybe. It was explained to me, maybe they would if, you know, that was part of their duties somehow. Dealing with COVID-19 issues, it was expected that, you know, they might get sick in the course of their employment. So possibly there could be coverage for workers' comp, but again, that doesn't really relate directly to our example of liability for the, you know, person catches COVID at the pool, but it's nice to know. And again, how do you prove it? That's a whole other question, and I don't know how you prove it. It's going to be difficult. How do you prove they caught it there and not somewhere else? I mean, I admit that that'd be very difficult. Next slide, Melissa. All right, so are we covered? The decision to reopen your amenities. In sum, there's likely no DNO, likely no property insurance or liability coverage either. So we've talked about why that is. Your ability to reopen may vary greatly county to county. You know, we've seen in Michigan, they've reopened for all the counties, but there's gonna be different requirements. So you need to know what your county requires for reopening. And who enforces the county, the CDC requirements. It's absolutely imperative that you do try to follow the county and CDC standards, or rather the people who hire cleaning the pool do follow those things. It is important to do that for liability purposes, but you should outsource it to third parties for liability reasons. Follow those CDC guidelines, have your people follow those guidelines, increases the chances that we'll have defense coverage if there is a claim. You know, the question is, how much is it going to cost to pay our third parties to do this stuff? How much additional costs are we looking at to reopen our pool? And what does your community want? Every community is different. I don't say all communities have to do a certain thing. I never say that. I think that you have to look at the unique circumstance of each community. Some communities may have higher risk than others. Maybe they have more vulnerable population than others. So you need to really know your community in making this decision, as you do any decision. But as Ed said previously, the wind certainly is blowing in favor of, you know, this is a high risk, and you probably should think very carefully about whether or not you reopen this year. And if you do, you got to be very careful how you do it. Is that my last slide, Melissa?
I think that you have one more, but there's a couple more questions. So
I know I want to get to Ed's portion, so let's finish my slides and then we'll come back to this.
Okay. There you go.
All right, so in sum, other thoughts, takeaways, be flexible. Nobody really knows. The insurance people don't know how this is all going to turn out. They don't know. I mean, they're like, this is uncharted waters. It's uncharted waters for them, so it's uncharted waters for us and for you as boards. So you need to make the best decisions you can. Make fact-based decisions based on the evidence before you and what the experts are telling you. That's how you make your decisions. Communicate with your members about why you're making your decisions. If you decide not to open your pool, make sure you explain that, explain why you didn't. That will help whatever decision you make go over easier. Use technology to expand your communication abilities. You know, we can do Zoom now, we can do email to communicate with our members. Waivers are not a panacea. You can't waive the kids' rights. So any kid using your pool, they can still sue you when they turn 18 for at least a year. So, you know, as I said, limited value to waivers. You also cannot waive gross negligence or willful and wanton misconduct. You could only get a waiver for negligence. So that's by law. It doesn't matter what you put in the document. But your waiver should be carefully drafted to be enforceable. If they're sloppy, then they're easier to poke holes in. I've already covered most of these other boxes. Again, the last thing I'll leave it as we move into the nonprofit corporation issues is review your documents, review your articles of incorporation and your bylaws for protections for your directors and officers. If you don't have certain protections in your articles of incorporation, then they don't apply. Even if they're in your bylaws, they don't apply. There's certain things that have to be in your articles of incorporation for liability protections. Make sure you've had an attorney look at them, make sure they're up to date under the Nonprofit Act. And again, just a special thank you to Scott Breslin from McCree Insurance. If you have any insurance related questions for HOAs or condos, I'd recommend give him a call. He's the guy who knows a lot about the insurance angle of all these questions that I've been talking about. And with that, I'm gonna turn it over to Ed C.
All right, thank you, Greg. I'm going to talk about nonprofit corporations and how the COVID-19 pandemic has affected nonprofits. A nonprofit can include an educational institution, a charitable organization, trade associations, or homeowners associations. But if you're formed as a nonprofit in Michigan, you are subject to the requirements of the Michigan Nonprofit Corporation Act. In fact, you're subject to 4 governing documents. The first one is the Michigan Nonprofit Corporation Act, which is the most important one. The second is your Articles of Incorporation. The third is your bylaws. And the fourth is any policies that you have adopted. So the first question I want to talk about, what are the consequences under Michigan law for not having held your annual member meeting? Now, because of the pandemic, because of the CDC guidelines and Governor Whitmer's executive orders, we can't have meetings. So most nonprofits have not had their annual meeting. But Michigan law provides that a nonprofit corporation shall hold an annual meeting each year to elect directors and conduct any other business that they want to conduct, unless the members act by written consent or by ballot. And I'm going to talk about written consent and ballot a little later. That's an exception to the annual meeting requirement. In addition to that, most nonprofit bylaws will say that the organization has to have an annual meeting. So if the annual meeting was not held, Michigan law provides that the meeting must be held. In fact, the board shall cause the meeting to be held within 90 days after the date that it was supposed to be held. And if it isn't held within 15 months after the date of the last annual meeting, that the circuit court can order that a meeting can be held. So Michigan has a very strong law requiring all nonprofits to have an annual member meeting. The law also says that failure to hold an annual meeting does not affect otherwise valid corporate acts of the nonprofit or give cause to dissolve the corporation. So those are 2 good things. Now, what are the exceptions to having an annual meeting? There's really 3 alternatives to not having an annual meeting. And the first is that the members can act by conference call or video call. And that's become more and more common. Everybody's acting by video call, by Zoom. And that requirement will satisfy the annual meeting requirement unless your bylaws or articles do not allow you to do that. You can have that by video call or conference call, regardless of whether that's in your bylaws or articles. Under old Michigan law, you had to have that in your articles or bylaws. Under new law, you can automatically do that unless the bylaws or articles prohibit that. Okay, members can also act by written consent. By written consent, it means the organization sends them out a form, which we call a consent, which has a choice on it. And the member indicates their consent to that by signing that and sends it back. And that can be member action instead of an annual meeting. Now, the law says that has to be unanimous by all members. unless the organization has amended their bylaws or their articles to act by majority. So if you amended your articles, you can get action by a majority of members writing back to the organization. The third way to satisfy the annual meeting requirement without a meeting is what's known as by ballot voting. And ballot voting is one of the best things that's come to membership organization in years. This was made legal in Michigan about 5 years ago. And I'm going to talk more about ballot voting later in the presentation, but just suffice to say now that you, under ballot voting, if the organization has adopted it in their articles or bylaws, they can send a ballot out to all members. The members check the little box depending on how they want to vote and send it back, that can be a valid member meeting. So the moral of the story with annual meetings is that Michigan law requires an annual meeting and everyone should have one every year. And if you haven't had one for this year, which you probably haven't, that you should schedule one as soon as possible. Okay, since we can't have meetings, many organizations are doing remote meetings. So I want to talk to you for a second about how to properly conduct a remote meeting. First of all, as I said earlier, any nonprofit can do it unless it's prohibited by the articles or bylaws. Notice of the meeting must be given like any other meeting, or notice must be waived in writing. A quick point on that is we all know we have to give notice of a board meeting or a member meeting. But in certain situations where there's not time to give notice, you can have all the board members or all the members sign a waiver of that notice requirement. And at that meeting, all members must be able to communicate with each other and to vote. You must have a quorum attending the meeting. And let me talk about quorum for a second. For a director meeting, a quorum means a majority, but the members have the right to change that from majority to more than a majority. They could require like 2/3 or 75%, or all of the directors have to be present to be a quorum, or they could reduce the quorum requirement, but it can't be reduced lower than 1/3 of the directors. Now, for a member meeting, again, the law says a majority of members is a quorum at a meeting, but the law also says the members can change the quorum requirement. They can raise it as high as they want, and they can lower it as low as they want. It's not restricted to 1/3 like the directors are. So theoretically, you could reduce the member quorum to 1 member. I mean, I'm being a little facetious there, but there's no limit on how low you want to make that. But well, that's a good thing for membership associations, because they can't always get a majority of members to respond or come to meetings. At the same time, it could be sort of dangerous if you put that quorum too low. For instance, if you've got 100 members in your nonprofit, ordinarily a quorum would be 51. If you lower the quorum to something like 20, then 11 members would be able to take action for the whole organization. So for a 100-member organization, 11 members could amend bylaws, amend articles, and take any other member action. So it's flexible, which is good, but you have to be careful with it. Now, how voting is conducted at a remote meeting isn't really addressed by Michigan law. But what I generally see by voting at a remote meeting is it's done by voice vote, which means the chair says, okay, all in favor say aye, all opposed say no. It's done by polling the members, in which every member is called out. How do you vote? It can be done by raising of hands. If it's at a video meeting, it can be done by raising of hands to count the votes, or it can be done by electric transmission from a meeting. So if you're at a validly called member meeting and it's time to vote, each member could electronically transmit their vote into the organization. Although the law doesn't specifically say that, it can be done by, I'm going to go out on a limb and say that can be done by email, or it can be done by text. Any type of electronic transmission where the organization can keep a record of the voting would be allowed. Any action at a remote meeting must be approved by a majority of the votes cast, unless a higher amount is set by the bylaws or articles. So ordinarily, it's a majority of votes, unless you want a higher requirement than a majority. Proxies can also be used at member meetings. Proxies are good ways to get members to participate or to meet the quorum requirement. Proxies, a member just has to sign the proxy, fax it back in, and that helps go towards the quorum requirement. Any action? Yeah, go ahead.
This is Melissa. I'm sorry. We have a couple of questions. So
Yeah, go ahead.
the first question is, do all members need to vote to override the annual meeting in person requirement, or can just a majority of the members of the association agree to have a remote meeting?
No, that's really a board decision on whether they want to have a remote meeting or not. That's a board management decision. So the board can actually call a member meeting when everyone has to come in person, or they can say, we're going to do a remote meeting.
Okay, and then if your bylaws require in-person voting at an annual meeting, but are otherwise silent on having a virtual annual meeting, do they just need to have the virtual annual meeting without voting?
Okay, did you say there the bylaws say you have to have an in-person meeting?
You have to have in-person voting.
Okay, if the bylaws require you have to have in-person voting, then you have to have an in-person meeting, unless the bylaws are changed.
So they could just have, but could they have just an informational meeting remotely?
Oh, yes, of course. Yeah, they could do that. Yeah, they could have informational meeting, but if your bylaws require in-person, then you've got to have in-person voting, or they have to change the bylaws.
Okay, thank you.
Okay. Okay, and then Michigan law also provides that any action taken at a meeting that was not, well, that's at an invalid meeting, should I say, that was not properly noticed, or there wasn't a quorum, or voting wasn't done properly, any action taken there has no legal effect and can be challenged by a member or by a director or by the Attorney General's office. Also, any action taken at a meeting that you realize later that maybe you haven't followed all the procedural rules can later be ratified by the board or by the members. So if you had a board meeting or a member meeting and you think that maybe, or somebody's questioning what happened there, maybe it wasn't properly noticed or something wasn't done properly, you could, at the next meeting, you could ratify what was done at that prior meeting, and that would correct any problems with the first meeting. All right. So that was all about how to do a remote meeting. Now I want to talk about how to take member or direction action without a meeting. So first of all, director action. Michigan law allows directors to take action without a meeting if all the directors sign a consent without a meeting, unless the bylaws or the articles or your policies prohibit it. So if you can get every director to sign the consent of a meeting, that's a valid act. You don't have to give notice. You don't have to worry about quorum or anything, but you have to have every director to sign that consent form. Okay, other than that unanimous written consent form, directors have to hold a meeting in person or by remote electronic communication. I should also mention there that directors cannot give a proxy to another director in a membership organization. That's something I run into a lot, where organizations are doing that, or they're asking me if they can do it. And no, that is prohibited by Michigan law. Directors cannot give a proxy at a membership organization. But in a directorship organization, which is a nonprofit that does not have members, has directors only, a director can give a proxy for the sole purpose of voting for directors. Okay, now how can members take action without a meeting? Members can take action by what we call ballot vote if the organization has put in their articles or their bylaws that ballot voting is allowed by the organization. Ballot voting must comply with the requirements of the Michigan Nonprofit Corporation Act, which really aren't too onerous. Essentially, the requirements are the ballot has to set forth the proposed action to be taken. It has to provide for a vote, like check the box on who you want to vote for. And then the ballot has to be returned, and the ballot has to say how many days does that ballot have to be returned. And it can't be less than 20 days or more than 90 days. So, if the organization receives ballots that exceed the quorum requirement, that's a valid meeting. So I strongly recommend membership organizations to adopt ballot voting. It's really a modern way to operate, and some organizations were sort of doing it anyway, but it wasn't really allowed by Michigan law, but now it is. So I recommend that you look seriously at amending your articles or bylaws to allow for ballot voting by members. And then members can also act by unanimous consent. If you can get every member to sign a unanimous consent, which is pretty difficult for most organizations because they've got a lot of members. Or if you have amended your articles or your bylaws to provide for a majority of the members to act by written consent, you can act by the consent of the majority of members. Okay, so those are ways that organizations can act without a meeting and can be very helpful to operation of nonprofit corporations.
I have a couple other questions. This is
Yeah,
Melissa.
go ahead.
One is, if your documents force an in-person meeting, could you conduct it outside?
When you say outside, what do you mean outside?
An outdoor gathering?
Yes, you could conduct an outdoor gathering. Yeah. Mm-hmm.
You just need to follow the no more than, I believe right now it's 100 people rule outside.
You mean the CDC rule?
I believe it's in the June 1st executive order of the governor.
Yeah, you got to satisfy the CDC rule and the governor's executive order. Yes. But yeah, you could hold it outside or you could hold it indoors. Yes.
And then someone else would like to know, what's the specific criteria to know when the COVID guidelines expire?
I mean, is that I'm not sure what that, relates to, which topic, but I mean, the executive order of the governor, I would think, addresses that and says, we got to follow social distancing, and for how long, I would think that that's there. And, that refers to the CDC guidelines. So I think it's up to the governor when those things expire. Would you guys agree?
Yeah, they don't have an expiration date at this time, so they'll continue until the governor changes or issues when they terminate. Yeah.
And I believe that the CDC would have to walk back their guidelines for those to be expired. So until they back them down, then you are bound by them. So someone else's question is, you've said before you can't vote by email on action of the board, even if it's unanimous. So is that action without a meeting by a board to be voted upon by ballot?
Ballot voting is for members only. Directors can't vote by ballot. Directors can only act by unanimous written consent or by having a meeting in person or electronically at which proper notice was given and a quorum is at the meeting.
Right, but
So I think what she's saying is, if you vote by email, how can you make that a valid action if the board votes by email?
Okay, board can't vote by email. Board can only act by unanimous written consent or by holding a meeting. Members can act by ballot, but board cannot. Board's got to have unanimous written consent or they've got to have a meeting.
well, I think what we would say is, for the condo and HOA context, if you have electronic transmission, if something is required to be in writing and it's transmitted electronically, then that would be a valid consent, right?
Yeah, you're saying can they vote by electronic transmission to a unanimous written consent? Is that what you
Right.
mean? Yes, they can do that. Yeah.
Because that's
Yeah,
what
you
our,
can
you know, one of our clients, I always
Right.
tell them, technically you can't vote, you can't do board meetings by email, even though everybody does. And you know, it's gotta be unanimous if you're gonna do an email consent. They don't like that. A lot of them don't believe in that or don't follow it, but that's what the law is. And I would say you take those written consents and you attach them to your minutes for your next board meeting, so that there's a record of what was done by unanimous consent.
Yeah, yeah, that email can be a written consent.
Right.
And so I think that would still meet this requirement of the law. But you got to have every director send it in their consent electronically.
Right.
But then you can ratify it at your next meeting.
Yes.
You can do that too, yeah.
Yeah, you could ratify it next meeting. That's a good point. Yeah. We've got a question there by Jasper, Melissa. Did you see that?
Yep, it just popped in, so they want to know, he wants to say, to be clear, you can have a board meeting by Zoom or teleconference, correct?
Yes, that's automatic unless your bylaws or articles prohibit it. All right. And the last question I want to get into is one that was already addressed partially by Greg, and that was, can our organization be liable if someone contracts COVID-19 at one of our meetings or in the workplace? And as Greg said, yes, the answer to that is yes. And really the question is, did the employer meet the standard of care that an employer is supposed to meet? And the best way to meet the standard of care is to follow the CDC guidelines or the governor's executive orders. Majeure also has a whole new website on workplace safety. So you should follow Majeure governor executive orders and CDC guidelines in the workplace. And then the question will come down to, was the employer negligent? Or did the employer meet the standard of care that they were supposed to meet? And then the other question is, can they prove it? Greg already hit that, difficult to prove. But it is an area of law that's evolving. It's just become an issue. I think we're going to see a lot more cases about this. And so this is all, will all start to be flushed out in the near future. And that concludes it. We have time for questions if anyone else has questions.
Thanks. I had a question for you, for the two Eds. You know, you talked about doing your annual meetings or membership meeting by means of remote communication. Have either of you actually seen or heard of any membership meetings being done by means of remote communication or electronic transmission, especially now?
I'm not aware of any, Greg. And to that point, I've heard an awful lot of questions about that. You know, associations are exploring that possibility. And to that end, there are third parties out there that sell their services to facilitate your ability to have people participate in meetings by remote communication, whether it's electronic casting of ballots or just simultaneous communication. So I'm aware that those kind of procedures are out there. I have not seen anybody use it though.
Yeah, I would agree with that. Annual member meeting has always been done in person. It was as much of a social event as it was of an annual business meeting, but we can't do that this year. So more and more folks are looking at doing that electronically.
Okay.
Okay, so questions for Greg regarding the clubhouse. Should people not be opening their clubhouse and doing rentals at this time?
I have the same concerns about amenities in general. If they were closed, you might want to keep them closed. If you open them, you need to be very careful, understanding that, again, there may be no insurance coverage if something bad happens. If you get sued, you know, if you have a clubhouse that you know is frequented by many, many members, then I think that's a higher risk, and you're you're taking a chance. If you're going to keep the pool closed, why would you open something else that would have the same effect of people? If you know there's a high risk of people gathering there on a regular basis. And if you do open it, I think you need to have a comprehensive strategy of, number one, having waivers, number two, posting warnings, number three, have a plan of action that's similar to what the counties are having about their pools. Have a plan of action as to how you're going to comply with the requirements to clean the surfaces, cleaning frequently contacted surfaces, all that other jazz. You need professionals to do that. You need to have a plan in place to show that you're doing it. So I think the same concerns are present, and nobody's saying that people get COVID through the water, right? It's not the pool water that's you're getting the contagion from. It's the gathering of people in a small place like that, usually with just swimming clothes on, right? There's furniture around that ton of different people use. So maybe a pool scenario is a little higher risk than a clubhouse that is used or rented on a less regular basis. The risk may not be the same, but I just keep going back to liability. Are you willing? Do you have the money to defend yourself if you do get sued? I mean, somebody mentioned in the chat, have we seen a lawsuit yet? No, we haven't seen. I mean, I haven't seen one yet. I'm sure they're coming. So I'm sure you're going to see lawsuits related to COVID, as well as related to insurance issues related to COVID. So when insurance companies say, we don't want to cover this because it's excluded by a pandemic clause, then you're going to have people fighting over that. So this is, again, uncharted territory for all. And you need to make the best decision you can for your community. Best decision could be we don't open in 2020. We keep those facilities closed. I think that's a legitimate decision. People will be upset. Not saying they won't be, but you're kind of in a tough place. It's a no-win scenario with risks on either side. What do you guys think about that, Ed? I'll throw that to you guys.
Yeah, that is a tough decision. The conservative and safest thing to do is to not open the pool.
Yeah.
Otherwise, you're taking the risk of an expensive lawsuit without insurance coverage.
Ed Z.
Okay. Question, real quick question. Do the COVID exclusions for coverage that apply to pools also apply to if you guys held if an annual meeting is held and someone says they got COVID at your annual meeting?
An interesting question. You have a duty to hold an annual meeting, and you don't have a duty to open the swimming pool. So there, I think you're talking about a different set of circumstances. You would, however, need to be sure that you observe all objective criteria for holding that meeting. Not, making sure you don't exceed the number of participants that are allowed, making sure that social distancing is observed. And I would be concerned that if you hold a meeting and don't do those things, then you might be subject to a claim for negligence by someone who is infected.
Okay, and then can an adult sign a waiver to limit liability relating to an individual contracting COVID at the pool?
An adult can for themselves, right? As I said earlier, like you cannot sign a waiver to waive all of your child's claims. There's a case on that came out 10 years ago or so, said you cannot waive with a waiver like that a minor's rights. So, and I believe there's a statute on that too that says they have a year after they turn 18 to pursue a claim related to a tort, or something like that. So you can't. That's one of the holes in the whole waiver idea, because if you got a bunch of kids using the pool or using the playground, the waivers are really they're worthless in the long run. You're gonna have that long tail liability. And the other hole I mentioned is the type of claim that's brought. Plaintiff's lawyers will try to get around the waiver. They'll either say it's badly worded, it's ambiguous, it's not clear enough, it didn't expressly waive the negligence claim. Or they're going to say this was not just negligence, this was what they call gross negligence. Or even worse, it was willful or wanton misconduct. And those are two kind of higher thresholds to meet against somebody when they did something wrong. And the law says that you cannot get a waiver for that. Like they cannot protect, association cannot protect, the board cannot protect themselves for their own gross negligence. What's gross negligence? It's basically even worse than negligence. It's you acted with a substantial disregard to the risk of that your actions would cause injury to another person. So it's a higher standard for a plaintiff to prove that you acted with gross negligence. So it's not easy, but if they prove it, your waiver is worthless. So another hole for waivers. You can have waivers for negligence. If you want to say, we're going to demand everybody to waive any negligence claims they as adults could bring against the association for opening the pool, and if they got sick, yeah, that would in and of itself on the common law, I think that negligence waiver is enforceable. Assuming they can't poke a hole in the way it's worded. They might say it's, as I said, not clear or not express enough. There's a whole case law on that, on the language of waivers and how clear they have to be enforceable. So it's not, and I've also heard of insurance people just saying, forget waivers completely. They're totally worthless. They're not worth the paper they're printed on. I mean, you could have a waiver in hand. Does that stop somebody from filing a lawsuit against you? No, it doesn't. They can still sue you. Then you're going to defend and say this claim is barred by waiver, and you're going to try to file. You might try to get the case tossed right away. You might file a motion, toss the case right out of the gate, and maybe you'll win. And then maybe the case only costs you $5,000, $10,000 instead of $100,000 or $200,000 to defend. So again, the waiver doesn't protect you from just being sued, period.
Then a question is, if you post warning signs, doesn't that support the case against you for expected injury inclusion or exclusion? So if you post warning signs, are you saying, hey, you could be injured here and we would be liable?
I don't think so. The risk is there regardless. Even if you don't post the sign, they're going to say, what are you doing? You're reopening the pool. We just had another 200 cases of COVID. So I don't think there's any additional risk by posting a sign. The risk of COVID is there. It's undeniable. So I think you only gain by putting the sign up. When I've looked at case law dealing with signs and warnings, they say generally, yes, you should have some kind of a sign to put people on notice that this is a risky situation, and they are assuming the risk by putting themselves in that situation. So the BI exclusion is going to apply regardless, so it's already going to apply. So why not have the sign to at least try to protect yourself from those other types of claims, negligence claims?
And how could the board be committing a wrongful act if the county does an inspection and says that everything is good and the pool can be open?
Ed Z, you want to pipe in on that, or?
Yeah, a claim is going to look at the totality of the circumstances wherein the board made its decision. The board is charged with exercising reasonable business judgment and making all its decisions. And if you were going to file a suit and claim that the board did something wrong, you're going to try and show that the board did something that was unreasonable. Certainly one of the things that we are stressing is that the board's decisions need to be based upon objective factors. And so the board would say, well, the county said it was that we could open and we followed their guidelines. Therefore, we were not negligent. And it's actually a good argument that you would try and make, but it doesn't get you out of jail free if you are sued. They would still examine any other factors that might be available to show that somehow the board's decision was not correct. The opposite of that, however, would be if the board made a decision that was contrary to a published policy by the county in which the pool was located, then the argument would be that the board was negligent as a matter of law because it made a decision to act counter to government regulation. So yeah, that's something to keep in mind. I think, Greg, there was something else that I wanted to add too. The question came up that a pool's a common area like a lobby. Couldn't a resident hypothetically also sue the board alleging they caught COVID from a doorknob? And I suppose that would be true, but what I want to point out, the distinction between those two examples is that one is likely to be seen as an essential service in the community, whereas the opening of the pool is not an essential service. And so that distinction is going to be important. For example, could you say all fire escapes are closed due to COVID until further notice? No, fire escapes are essential. And so, you know, you're going to have to leave those open. Doorknobs for common hallways, you know, yeah, those people have to use them to come in and out of the building. And so what's the duty of care with regard to those shared surfaces? You may need to take a look at your practices and be sure that those shared surfaces that are touched regularly but essential are being properly cleaned.
Okay, so if the policy has a bodily injury exclusion, then does that transfer as well to the workout room if somebody is using broken equipment, or if they somehow break their leg in the workout room? And what do you recommend boards do when they have those types of places?
Well, again, that's a little bit different. You're talking about something that I think would be covered by your liability, just general. If you got hurt on any facility, you're going to have, in any facility of the association, you're going to have your regular liability coverage would be in play. Now let's say if they get, that's different. If you break your leg or something, that's different. If we're talking about injuries that arise directly as a result, the end result of the board making a decision to reopen or not an amenity, the board controls that. The board of directors controls whether to reopen the pool. The board of directors controls whether to reopen the workout room. So yeah, I do think the same logic applies as to if it was a claim and you're asking whether you'd have DNO coverage for that. I think the same exclusion would apply. It's the same reasoning. You made a decision to reopen your workout room. You knew that you're going to have 100 people in there every day, or 50, or whatever size it is. You knew that, and you know, somebody contracted COVID as a result of that. So I think the result is the same as far as, you know, that exclusion is concerned.
And that workout room was not essential.
Right.
Not a fire escape.
Any other questions from anyone? Please don't forget, if you want to copy the presentation, you can drop your email to me in the chat box to Melissa, and I will send out the presentation to you. If you are watching us on Facebook, you can comment to Stacia and she can send that to you as well.
Okay, anything else? Any other questions? I think we're out of time, so. Thanks everybody for attending. I hope you found it informative, and check back with us again in a month for our condo and HOA beats. We'll have more sessions like this.
Thank you, everybody.
Yes, thank you, everyone.